I'd like to welcome you all to this webinar to launch the report, How Can Victims in Ukraine Be Heard Before the ICC? And this is a guide designed to help CSOs, survivors, and affected communities in Ukraine understand the role of the ICC, as well as the rights of victims and survivors before the court and their opportunities to participate in the court's proceedings. A couple of housekeeping issues before we start. Hopefully, now that I've started speaking, those of you who want to use interpretation between English and Ukrainian have found the interpretation function. If it doesn't appear on your screen, try clicking on More with the three little dots, and you should see the option for interpretation. And then you can choose the language that you want to hear the webinar in. And the second piece of housekeeping is that at the end of the session, we're aiming to have a question and answer session. So as you're listening to the panelists, you may think of questions that you want to put to them at the end. And if so, please can you post them in the general chat. You may see a function that says question and answer, but please don't use that, use the general chat. So I'd now like to invite Benji Alan Aquino from REDRESS to start us off by introducing the report. Thank you, Benji.
Thank you, Fiona. On behalf of REDRESS, good afternoon, everyone. Thank you for joining us today as we launch the How Can Victims in Ukraine Be Heard Before the International Criminal Court? A guide for survivors and affected communities to understand the ICC proceedings and their rights before the ICC. The publication of this guide marks an important step in our collective effort to ensure that victims of the ongoing conflict in Ukraine have access to clear, reliable, and practical information about the ICC and how it works. Ukrainian victims often face significant barriers when trying to understand and engage with the ICC. While the court has made substantial outreach efforts, the complexity of its procedures, coupled with emotional and logistical challenges that victims endure, it can make its work difficult to access. And this is where civil society organizations may come in. The guide responds directly to these outreach and accessibility challenges. Although other documents and resources designed to guide victims and CSOs in engaging with the ICC already exist, many of these materials are written in highly technical language or would omit important caveats about managing victim expectations. This can leave victims feeling overwhelmed or with an inaccurate understanding of their rights and the court's processes. Recognizing these gaps and responding to asks from Ukrainian CSOs, we sought to create a resource that is not only comprehensive, but also accessible, practical, and sensitive to the realities that victims face. On behalf of REDRESS, I'd like to thank everyone who has helped in the production of this guide, the Center for Civil Liberties, or CCL, the Human Rights Protection Group, ZMINA, Ukrainian Legal Advisory Group, and the Kharkiv Human Rights Protection Group, who have all provided their inputs in drafting the guide. These are all Ukrainian CSOs who helped shape the contents of the guide. A special thanks also to the experts who helped validate the accuracy and reliability of the information, Megan Hurst, Fiona McKay, who's moderating our launch today, and colleagues from the Victims Participation and Reparations section, as well as the Public Information and Outreach section for lending their expertise to this endeavor. The Ukraine ICC Guide is designed to serve both CSOs and individual victims. To achieve this, we've created two versions. The first is a more detailed document, which CSOs may find particularly useful in their advocacy and support work. And the second is a concise 4-page overview intended for a wide distribution, especially in communities. And both versions are written in accessible, practical language, avoiding unnecessary legal jargon. The guide not only informs victims about their rights and the ICC's processes, but also emphasizes the importance of managing expectations. It explains what the court and its various organs and programs can and cannot do, ensuring victims have a realistic understanding. Tailored specifically to the Ukrainian context, the guide draws on examples and jurisprudence from other ICC situations and cases. It also includes Ukraine-specific information, making it a uniquely relevant resource for the audience. At the same time, its structure, following the stages of ICC proceedings, ensures that it could provide practical information on the court's processes and the victim's rights for other situations. The guide covers every stage of the ICC process, from preliminary examination to reparations, and highlights assistance programs available to victims along the way. It contextualizes key concepts within the Ukrainian experience, providing clarity on how these processes may or may not apply to the ongoing conflict. Moreover, the guide contains annexes. One is a list of useful materials which can be consulted for further information, while the other one provides contact information of civil society organizations that may assist victims in engaging with the court. This ensures that victims have access to organizations that may be able to help them act on the information that they gather from the guide. If there are any CSOs here in the attendance, we suggest that you reach out to us if you want your contact information included in this annex as well. Finally, as we move forward, we are happy to share that REDRESS is already exploring plans for derivative products to expand the reach and impact of this guide. For example, we plan to produce child-friendly materials to ensure that children who have also been directly affected by the crimes the ICC is investigating in Ukraine can benefit from this resource. Once again, on behalf of REDRESS, I want to thank everyone involved in the creation of this guide, from the drafters and the reviewers, and to the CSOs and experts who shared their invaluable feedback. Let us continue to work together to empower victims and uphold their rights, not just in Ukraine, but wherever they seek justice. Thank you.
Thank you so much, Benji. So now I'd like to invite the first of our panelists, Yelyzaveta Sokurenko, to speak, who is head of the War Crimes Documentation Department at the Human Rights Center ZMINA. Yelyzaveta, can you tell us about how CSOs are working with affected communities in Ukraine?
Yeah, hello. So I also want to apologize in advance for the possible noises on the background, because I had recently adopted a puppy and he's somewhere here doing his puppy stuff. So he may bark a little. So sorry for that. Actually, it would be quite hard to tell in 10 minutes about Ukrainian CSO work on affected community, but I will try to give you some brief information, and all of you can contact me whenever you want with whichever questions you had in mind. And I also wanted to, first of all, to thank REDRESS for the invitation to participate in this presentation and to comment on the guide, actually. Our organization, Human Rights Center ZMINA, has been working in the field of protection human rights in Ukraine for 12 years already, and we work with various topics. But since the beginning of the full-scale invasion, we have also begun to document international crimes committed by the Russian military and security service personnel against the civilians in the occupied territories of Ukraine. We mainly work with cases of arbitrary detentions, enforced disappearances, torture, and inhumane treatment of civilians. The main source of information for us is in-depth interviews with the survivors, which we conduct in particularly during regular field missions to the liberated territories of Ukraine. So we also work with the information from the open sources, and we do provide lots of legal analysis. So you can find some on our website. It's ZMINA UA, very simply. The main conclusion that our analysis, the analysis of the data we have collected over recent years show that the persecution of the civilian population in the occupation is planned, systematic, and large-scale policy of the Russian Federation. And this policy is designed to suppress any disagreement with the occupation and eradicate any Ukrainian identity by creating an atmosphere of fear and impunity, actually. So the number of survivors of crimes is incredible. Our organization have interviewed like more than 300 with the help of the team of just 4 documentators. So, and we see that the consequences for both the psychological and physical health for the survivors are horrifying. However, when we started interviewing survivors in 2022, after the liberation of the part of the Kharkiv region, we saw a high demand for justice among the survivors. Unfortunately, and over time, this has been replaced by a certain disappointment, in particular because investigations into such crimes take a long time and need much effort. On the one hand, in order to avoid unjustified expectation, society must have an understanding of how accountability mechanisms work. So the creation of the guide, which is being presented today, is like one of the necessary steps toward this. So Benji also, Mr. Benji, Mr. Alan Aquina also said some of similar thoughts at the beginning in his speech, and unfortunately it's true. So there, I think there is, it seems that there is no person in Ukraine, even in the remote villages, who has not heard of the ICC. At the same time, not everyone understands its role and how it actually works. So I hope, and I'm sure this guide will help. We are not only a human rights organization, we also do a lot of information work, information campaigns, and we will like produce this guide among journalists in a specific journalistic format, so every person could understand it. It could have an access to that guide. So, but on the other hand, we see that current accountability mechanisms do not work when one of the parties of the conflict does not comply with the international law. And finding a solution to this, I think it's also our common duty. So it's important also to understand that Russia continues to commit crimes in those regions of Ukraine that are still occupied. Also obtaining information has become much more difficult from the occupied territories. I'm sorry. It's not a new thought that to a large extent, the investigation of the unprecedented number of these crimes is the responsibility of Ukraine itself. So Ukraine needs a reliable system of criminal investigation based on international law, and I think we're moving towards this. I'm sure you are all aware that Ukraine have finally ratified the Rome Statute recently. However, we cannot stop Russia's impunity and achieve justice for survivors without international support, without your support. Still, we need to win the war on the battlefield first. I will stop here. Thank you very much for your attention.
Thank you so much for that really helpful introduction, and I'm confident that there will be many questions for you afterwards in the question and answer. So now I'd like to invite Caroline Maurel, Outreach Officer in the Public Information and Outreach section in the registry of the ICC, to make her presentation. Caroline, can you tell us about how the court is doing outreach to victims and affected communities in the Ukraine situation? Have you already been reaching out? And what are your plans? And how has your work complemented that of Ukrainian CSOs? Thank you.
Yes, thank you very much for inviting us today. It's an honor to be associated with the launch of a guide such as the one REDRESS produced today. So as you said, I work in the outreach unit of the ICC. The aim of the outreach unit is to bring the court and the courtroom closer to those that are the most affected ones by the crimes that are under investigation by the ICC. So for my part, I am based at the HQ of the court, and I am responsible for the outreach in relation to Ukraine as part of other situation countries. And I'm saying it for a reason, to show you the limit of the resources that we currently have on that function. So how do we bridge the distance between the court and the population in situation countries in general? We do it in many ways. It's always about being creative in order to face these resource limitations that I mentioned before. It always needs to be tailored to the reality of each country, but also of each phases or stage of the proceedings. And it is importantly always trying to complement what is already being done by others. And that's where I want to already acknowledge the tools that has been produced by REDRESS, that this guide for the survivors, that is an incredibly useful tool. I think explaining the ICC process, making it accessible and understandable is really what makes access to justice a reality for the victims and the survivors. It is a step that is necessary to make justice meaningful at the end of the day. Along these lines, the ICC also has produced some tools in order to understand how the ICC works, and anyone can find these tools today on the websites of the court, in the resource library. They exist in English and in Ukrainian. I'm just going to show one of them. That is an interesting tool because it is a compilation of questions and answers on the court. It is mainly to assist CSOs, NGOs to respond to the questions that they may be facing. And for this, I strongly suggest any NGOs that have already been facing with questions on the ICC to have a look at it. Maybe before saying more on the outreach, I want to clarify, because the public might have an understanding that is not very clear to me currently on the ICC. So I'd like to clarify a bit what is the ICC. The ICC is an independent international court, and I'm focusing on the word independent here. So we're independent from the UN, we're independent from governments, and the role of the ICC is to investigate and prosecute and try individuals, meaning not states, not groups, but individuals, for the international crimes that are the war crimes, crimes against humanity, and the crime of genocide, as well as the crime of aggression, with some limitations. As you know, the ICC is currently investigating on the crimes being committed in Ukraine. I want to remind a bit how it unfolded. So on the 28th February 2022, the prosecutor of the court, Karim Khan, announced that he was planning to ask the judges of the court to open an investigation. And after this, a group of 44 states parties to the court asked the prosecutor to start the investigation. And so that's how, on the 2nd of March 2022, the investigation actually started. The scope of that investigation encompass any past and present allegation of war crimes, crimes against humanity, and genocide that are committed on the territory of Ukraine by any person from the 21 November 2013 onwards. You have seen that in 3 different occasions, warrants of arrest have been issued by the judges of the ICC. So we currently have 6 warrants of arrest that have been issued. It is a bit of a tricky thing, especially when you're talking to somebody like me who was working in the public information of the court, is that these warrants of arrest have been announced publicly. We got a little bit of information, but the warrants themselves, the details of the charges and of the scope is confidential. And this has been decided by the judges in order to protect the victims and the integrity of the investigation. So what is next? What is next for the ICC is that these warrants of arrest have to be enforced. The individuals have to be arrested. This is really what's next. It is important for me to remind here that the ICC does not have a police force, doesn't have an army. So the responsibility to enforce these warrants of arrest rests on states. On the side of the outreach unit for us, now is the moment to raise the level of understanding of the ICC in general in Ukraine. What is the ICC? What is not the ICC? What we can do, what we cannot do. What are the stages of the proceedings? What are the next steps? And in that, the partnership with the CSOs is absolutely key. You on the ground have the capacity to hear much better than me at the HQ. What are the main concerns? What are the questions? We know that there's a big demand of justice, but what do we have to address first? How can we address it in the best way? So monitoring the media is something that we do, but of course, you are in touch with everyone in the ground, and identifying the misinformation, identifying the misunderstandings is a very important step in order to clarify these points. So the production of tools is something that the outreach is doing and is promoting, just as this wonderful guide that you're launching today. We have started with raising the capacities of the media representatives in Ukraine so that they can report on the ICC in a more accurate and confident manner. I had last month a group of 10 journalists from Ukraine spent a week at the court and met the different counterparts, were given tools to report on the ICC, a better understanding, but also channels of communication. When they want to check facts, when they want to have quotes from the court, they know where to go and to which door knock. We work with NGOs. This is something that we have to continue and reinforce. But of course, we work with Victims Association, Human Rights Association in order to help them in what they're already doing to respond to the issues about the ICC, questions about the ICC. And I'm very aware that there's a need to have a sustainable approach to the outreach in Ukraine, and that there's only so much that we can do from the HQ. So we have requested to have an outreach field officer based in the ICC office in Kiev to the states that are actually meeting next week for the Assembly of States Parties to decide on the budgets. They will vote the budget of the court for next year. So I'm hopeful that we will be able to have somebody based in Kiev that will be able to put more efforts in this direct interaction in Ukraine, and that will be much more in contact on a daily basis with all this organization. Let's see next week. I hope we'll have a good news on that side. I will then leave my colleague from VPRS explain a bit more how do we explain the rights of the victims at that stage and how victims can be part of this justice process already now. Thank you.
Thank you very much indeed, Caroline. That was extremely helpful. So yes, indeed, I'd like to invite Dr. Philipp Ambach, who is Chief of the Victims' Participation and Reparations section at the court, also within the registry at the court. Philipp, can you tell us about victim participation at the court and the role of your section in facilitating that, including any steps you may already have taken in Ukraine, and how you see your section working with Ukrainian CSOs? Thank you.
Oh, I've been miraculously unmuted. Thank you. Thanks a lot, Fiona. And yeah, I'm really excited to be amongst all of you. And Fiona, again, Fiona is the mastermind of everything that I'm leading right now, because she was the one that brought this entire section into existence. So I just had to jump into the already created section. So yeah, all the happier to be here with you today. Thanks a lot for your questions, Fiona. Maybe yeah, to quickly start off in what is the role of the VPRS in terms of the victim process. And I'm coming straight to the guidebook document, which I have open in front of me. And really, I want to say this is where this document is so important, because it actually explains just this. The first thing I think that really need to be absolutely clear about is what is actually that victim role at the ICC. And again, here the document is very instructive. Basically, you can cut it into two. One is anybody who wants to provide any information to the Office of the Prosecutor that the Office of the Prosecutor may find interesting or important for ongoing investigations. Yeah, and for that, there's a portal, and the guide document outlines that in perfect clarity. And then there's the other leg, and that is the participation as a victim of its own right. And it cannot be overemphasized that there are these two different strings. Every single meeting that we have with Ukrainian CSOs, with any NGOs, CSOs, potential victim representatives across all situations, hone in on this first point. What can victims actually do? And oftentimes it is not properly understood or conflated what this victim's role is. Oftentimes, victim lawyers come to the court and say, okay, we understand our only role to be to bring victims' concerns to the Office of the Prosecutor in order to further investigations. That is not quite correct. Victims have their own specific role to play, if they want so, as a participant in the proceedings. Now, this is where the victim participation reparations section comes in. This is a neutral or part of a neutral organ organized by the registry, where victims can come in of their own right, completely independent from a potential provision of information to the Office of the Prosecutor or not. Victim of a situation is not only somebody who may have interesting information for an ongoing investigation. Victim is anybody who has been victimized, who has suffered harm from the violence, from the acts that could qualify as crimes under the Rome Statute. I think this is really important for everybody to understand. The majority, in fact, of victims that are participating currently in proceedings across the situations of the court have nothing important or relevant to add to the specific case as it is unfolding in the courtroom. Yet they have a perfectly legitimate position as victims to participate in these proceedings and to provide their views and concerns on matters that are dear to them. And this is all encapsulated in Article 68.3. What is the role that the VPRS now plays in all this? The role for us is to provide exactly this information to victims, to those that represent victims, and to those that may stand in between the court and victims or victims groups. And these may well be all the civil rights groups, civil society, NGOs. So basically us here in this forum today. So what we do is we try to explain what exactly this role is that victims can play. So what are the rights that victims can exercise during the investigation stage, during the case stage? Caroline already mentioned it to a certain extent. And then we are the ones that also provide the technical details as to how it works. So you have to imagine that the first step to be taken is that victim communities understand what their potential rights can be. In some situations, surely not in the Ukraine situation, you have to start even earlier. You have to explain, what is the ICC? What is our concept of justice? I think this is something that is due to the high level of sophistication of the Ukrainian general public, not an issue. Everybody, as Caroline said, everybody knows what the ICC is. Still, not everybody may know what exactly it is, the participation of victims in the proceedings. And Caroline mentioned it, there is a certain limited amount of participation possible. I'm now moving to Fiona's second question as to what steps have been taken or what are the procedural rights. There's a certain limited role of victims at the investigation stage, already from our perspective. And that is simply that victims can come forward and can submit their applications to participate in potential future judicial proceedings. This does not, and this is important, this does not provide them with an automatic right, for instance, to make any procedural submissions at this current stage of the investigation. The only way to actually interact right now would again be the direct correspondence with the Office of the Prosecutor. Obviously, in this case, if and when victims have something interesting to adduce that could further the investigation. But there is no right as such in terms of corresponding, say, with the pretrial chamber in the current stage with the current arrest warrants that have been issued. So that's an important point for us also to understand. Right now, victims can access the court, and I and my colleagues of the VPRS will try to explain to victims what their potential future rights, participatory rights can be. But as of right now, there's not much in terms of meaningful participatory rights that can be exercised as per the statute. Right? Quickly, sort of how this unfolds. The music starts playing really when a case starts. That is when we have the arrest warrants out, but in particular when we then apprehend somebody or somebody comes to the court of their own accord. Because this is the moment where we have the initial appearance, where the pretrial stage starts, where the proceedings against a suspect, later an accused, start, where the entire machinery of Rules 89 following kicks in, and where victims all of a sudden become rights bearers, so to speak, as a participant in the proceedings through their legal representative. And again, let me just make the parallel here again to this fantastic guidebook, because all this is explained in so much great detail. Sort of, what are your procedural rights? How does this legal representative come into place? What are the needs? What are the requirements for that legal representative to have in order to be able to be part of ICC proceedings? All that you'll find there in fantastic detail. So again, the key stage where I think victims' rights come in with force is the case stage. And that is, first of all, the participatory rights of victims. And then if it comes to a conviction, reparations. We'll get to that. But let me just quickly say one last point on sort of the technicalities, because that is what, you know, is what we're really doing on the technical level, and which is, I think, quite important for you to also hear. And that is what's currently happening. So currently, any victim of the Ukraine situation can reach out to the ICC, to the registry, and can seek to participate or submit an application form for participation in proceedings. Now, that application form will be one that has two segments. One is for participation in proceedings, and the other one is for reparations. That form can be filled in basically online. Yeah? Anybody can do that at any time. But at the same time, what we always say is reach out to us first, because it may be interesting for you to hear first how how we frame the whole situation. In particular, also, it's important for victims to understand that we have arrest warrants that have been issued. We don't know the content. And we don't know if and when proceedings will start. We therefore don't know if and when participatory rights of victims will actually kick in. We don't know if ever there will be reparations. Yeah, so these are all factors that I think have to be communicated quite clearly, because again, there's such a massive, I think, need for justice. And therefore, the messages that come from the ICC need to be crystal clear and well understood, which is why we're trying to always reach out and say, talk to us first before acting. That said, victims can submit their application forms at any point in time, and they are doing so. And we're trying our best to then provide the necessary explanations. So you will understand from this that the position that we as VPRS have been taking so far in the Ukraine situation is one that is not very active. We're rather reactive. We try to reach out to those that potentially are the first ones to reach out to us and say, hey, we would like to submit applications. We try to engage with potential legal representatives, one of them being in today's webinar. And we're trying to explain all these matters so that the CSOs, the NGOs, the potential victim representatives become our champions, so that they understand how the ICC works and how it doesn't work. And in particular, sort of that victims then receive that information. If there's still a lack of clarity, we're always the ones who are keen on doing trainings. But that is what's happening at this current stage. We would be training anybody who wants to understand how victim participation can work. This can be victim groups directly. This can be CSOs. This can be anybody who is dealing with victims' rights. So current steps, therefore limited. We're trying to provide the necessary application forms there on the internet. We've now done the necessary translations into Ukrainian, also Russian. So this is all accessible, and yeah, there we are. I think again, just one last word on this guidebook. Again, what I've been telling you right now is written in so much more detail and so much clarity in that guidebook that I really find this is sort of the key added value. You have a document, yes, 26 pages, but that's a real quality read for any CSO actor, because after that you really have understood from A to Z what this ICC is about. So really, I can only say thumbs up to the organizers. This is a fantastically useful document. That's it from me. Thank you.
Thank you so much, Philipp. And before I turn to our last panelist, I just want to remind everyone that after Haydée, we will have a question and answer session. So please do feel free to put your questions in the chat. Ideally, say which panelist or panelists you're directing your question to, and you do feel free to write your question also in Ukrainian. It's not necessary to write it in English. So looking forward to seeing those questions. And meanwhile, I'd like to invite Haydée Dijkstal to now speak. Haydée is legal representative of victims before the court in the Ukrainian situation. Haydée, can you tell us about how legal representation works before the court, how it helps to enable victims to participate and have their voice in the proceedings, and perhaps some of the particular challenges that you've faced in the Ukraine situation so far? Thank you.
Thank you, Fiona. Well, first of all, thank you so much for inviting me to speak today. And most of all, congratulations to Redress and to all the other contributors to this guide. You know, in looking through it, it's a fantastic guide, and I can see that it'll have a lot of, be very helpful to everyone involved in the situation in Ukraine. Absolutely, I can dig into legal representation at the court in the situation in Ukraine. And I think I'll probably be echoing some of the points that Philipp made as well about the different methods of participation, and do so from the perspective of the lawyers that are working with victims, the legal representative for victims, and particularly about making sure to enable meaningful participation at the court for those individuals and groups and communities that are being represented as victims at the court. So I think for the purpose of everything that I cover, I'll probably do so more with a focus on the early stages of proceedings, which is exactly the phase that the situation in Ukraine is in. You know, those early phases include the preliminary examination and the investigation stage. And as we know, the situation in Ukraine is in the investigation stage at the moment. So maybe what I could do is, one point I wanted to address is that meaningful aspect. You know, as I was preparing for this discussion, I was reminded by some of the early decisions from the ICC, which directly address the procedural rights and the procedural standing or status of the victims at the ICC, particularly in those early phases of proceedings, and the manner in which these decisions created a foundation, establishing what is understood to be meaningful participation at the court. So, you know, looking back at decisions from 2008, 2009, and the Lubanga and the Katanga cases, and I think it's worth reminding ourselves of this case law from time to time, just to make sure that, you know, when we talk about victim-centered justice, that we're focusing on those foundational concepts and core principles that were outlined for meaningful participation. So just by way of example, looking at, you know, in 2008, the pretrial chamber in the Katanga case looked at the procedural rights of victims and emphasized that the core text of the court provides victims with what it said is a meaningful role in criminal proceedings before the court, including the pretrial stage, so that they can have substantial impact on the proceedings. So this and other case law has emphasized the victim's personal interests are not limited to reparations issues, and that victim participation should encompass their personal interest in an appropriately broad sense and in a manner which reflects the nature and participation of victims. To make sure that it's meaningful and not just purely symbolic. It also notes that the issue of guilt or innocence of the accused is an issue which affects the core interests of victims, such that victim participation should not be confined to just reflecting on the victim's own harm, but also can extend during the proceedings to adjudicating the charges against the accused. So how the victims can weigh in on the evidence, or, you know, what they've observed as well. So what does meaningful participation mean to victims in the early stages of proceedings? And this is where I think I'll echo what Phil says about those two very distinct ways in which victims can participate, either with the office of the prosecutor or before the chamber, if there are proceedings that arise during these early phases of proceedings. So let me just turn to the ways in which legal representatives of victims work with, excuse me, the victims that were instructed to act on behalf of before the office of the prosecutor. So this, in the early stages of proceedings, the prosecution is evaluating whether, based on the information before it, there's a reasonable basis to believe that crimes within the court's jurisdiction have been committed, whether this warrants an investigation or even charges. And once there is an investigation, the prosecution is formulating the scope of the investigation and whether the prosecution will allocate its resources for investigation to certain aspects of that investigation as well. So this makes engagement with the prosecution and ensuring that your clients, the victims that you're acting on behalf of, that their evidence is heard by the prosecution. the consequence of not being able to be heard by and engage with the prosecution means that the prosecution might not be aware of the fact and evidence of the crimes suffered by the victims that you represent. So it, you know, and to this, I'm just going to note that the prosecution does have a policy. It's in the policy paper for case selection and prioritization, which it specifically says it promotes direct interaction with victims and victim associations at all stages of the proceedings. So there is a basis under the prosecution's own policy to interact with victims. But the question is whether in reality, in many situations that involved a very high number of victims, whether this policy is realized to the extent that victims feel they are truly being heard and can have an impact in the proceedings. And given that there's no set procedure or application process for this engagement, it can be difficult as a legal representative for victims to navigate this in order to best represent the interests of our clients, to make sure that the prosecution is hearing about our victims' harm and considering it when the prosecution is making decisions about the scope of an investigation. So let me then turn to the chamber, which can be engaged sometimes during the investigation stages. And what kinds of issues might this arise in? You know, here we look at the potential in the investigation stage where investigation stage and then the pretrial stage, if there's a case that's, you know, an indictment and warrants, arrest warrants as well, where issues like admissibility or a decision not to proceed with an investigation might become an issue. You know, examples of this is with the Afghanistan situation or in the registered vessel situation as well, whether or not there was going to be an investigation opened. And then there's issues also of protective measures in the pretrial chamber. In the Uganda situation has said that victims applying for participation may submit their views concerning protective measures. And then also on the preservation of evidence as well. This could potentially become relevant, and there could be proceedings that examine the preservation of evidence. An example here coming again from the Uganda situation, where the court recognized that the preservation of evidence has a bearing on the victim's personal interests, because evidence might disappear or be destroyed or deteriorate over time. So this is, I think, where those, you know, early case law about the meaningful participation becomes very important, such that you know, you're ensuring that there's a substantial impact in the proceedings and that participation is meaningful and not just symbolic. So let me just move on to some of the distinct challenges with the time that I have left. I just want to highlight two of them. One being the manner in which victims are recognized and allowed to participate in proceedings in the early phases of proceedings, and then the extent to which victim representatives get support from the court for their work. The first one, I think, one challenge that legal representative for victims often encounter is when raising the victim's interests before the court, before the chamber, during any of these types of proceedings that might arise during these early phases, and getting recognition for the status of victims and agreement, particularly on the manner in which they can participate and whether they can participate through counsel. The court's approach to this in the early stages of proceedings has been very diverse. Ranging from a decision from the pretrial chamber during deciding that victims can fully participate, through counsel in judicial review proceedings in the registered vessel situation, and then ranging all the way over to the opposite almost when the pretrial chamber's approach was much more restrictive in the Article 18 proceedings in the Afghanistan situation, where the pretrial chamber said that victims couldn't participate directly to the chamber through their counsel, but instead needed to submit any observations through VPRS. So this raised considerable concern among victims' representatives about whether this is in line and in the spirit of meaningful participation as envisioned in that early jurisprudence. Yeah, so let me then move on to the second. I know I'm mindful of the time that I have left. My last point that I wanted to raise is just one more challenge that legal representatives have before the court, and that comes with the status of victims, and particularly the status of their counsel before the court. So just, by way of background, legal representatives are often connected with clients in various ways, whether it's through CSOs, through local lawyers, sometimes directly being contacted by victims. And but then the formal appointment phase of proceedings, I guess, or the formal appointment of legal representatives comes at a much later stage once that case, once there's a case before the court, and the potential for legal aid and assistance only kicks in at that stage when that case kind of crystallizes before the court. Therefore, legal representatives are often very much on their own, often with clients that are in other parts of the world, maybe difficult areas to access, and with stretched resources, many who are acting pro bono and doing so for years, and with important needs like translation, investigations, and intermediaries that we need to work with in order to be in contact with our clients and to best represent their interest. And this is currently done without clear procedure from the court on recognizing when lawyers are acting as legal representatives for victims to carry out these really important preliminary steps to representing victims and making sure that during those early phases, they have their foot in the door and they can meaningfully participate. So just things as simple as access to the court, secure email, being able to file through the e-filing system, or even having support on missions to get access to our clients and be able to communicate with them efficiently. So, it's completely understood that the court can't assist and support every single legal representative for victims in seeking participation, for the victims that are seeking participation to the court. But given that there might be a number of different lawyers working in different groups, a lot could be done to establish guidelines and policies for when the registry and the court as a whole can interact with victims' counsel, recognize their status, and help to facilitate the meaningful participation at this early stages. And just to introduce them to all the things that are needed, which I know VPRS does so much. So I'm really glad to see this guide, which I think will be an enormous asset to legal representatives for the victims, in addition to all the other groups that are working with victims as well. So let me pause there, and happy to answer any questions.
Thank you so much, Haydée, and thank you to all the panelists for your extremely illuminating interventions. Thank you. So now we have some time. We have 30 minutes for questions and answers. And I'm seeing some come in the chat. Please do feel free to put some more questions. I'm going to start with a couple of questions that relate specifically to crimes of sexual violence. So the first one is, what safeguards can be put in place for survivors of, for example, the question says conflict-related sexual violence, because they're usually reluctant to come forward and report due to stigma, etc. What is the court doing to overcome these kinds of challenges? And a linked question, how does the court address the challenge of having limited information on wartime sexual violence, and especially in the occupied areas? Because as the question says, we know that rape is silenced and harder to document compared to other crimes. I wonder whether we might actually start with Yelyzaveta on that question, especially that last part, and then I'll invite the court representatives to talk about how the court responds to that. So Yelyzaveta, on this question of how to even document and initially hear about these kinds of crimes, given the stigma around the issue and the difficulty, especially of getting information from the occupied areas.
Yes, thank you. I will try to answer this question. So our organization do not work directly with cases of rape regarding the sexual violence in conflict, but unfortunately we do document sexual violence because it's a part of Russian practice of torture. We have sufficient number of using sexualized torture both against men and women during the interrogation by the representatives of Russia. So it's clearly and obvious that this topic is very stigmatized, unfortunately, especially in the Ukrainian society. Yet I see them actually quite a great push in the regional level, because, for example, in Kherson, we have a new non-governmental organization that was organized and consists of men survivors from torture and sexual violence who were illegally deprived of liberty by Russians. So they are recently they created a human rights organization. So they have a united community of survivors, and they are welcome to not only for survivors from Kherson region, but any other region of Ukraine that was under occupation. And they do provide psychological help for survivors. They do provide legal aid for survivors, and they, I think the most important, that they do talk with psychologists and with between themselves about their experience that they have survived from. So that's I think a huge step of for working with this stigma on sexual violence in cases of men. So I can only answer from this point of view, because in our organization, we only have one psychologist. So whenever we find case, we find a survivor of rape, a female survivor of rape or male, we do contact them with specialists. We do not document such cases without, because we don't have a professional psychologist who works directly with this topic. So we redirect the person to the organization which have such specialists. So yeah, and the other part of the question was, how do we document crimes in the occupied territories of Ukraine? So we have decided inside our organization that we do not provide interviews with a person if the person is still in the occupied territory, because it creates lots of safety risk for the person. I'm sure you know that they still keep doing house raids each month. They still do have checkpoints, and they can stop a person to check their person's cell phone or ID or else. But this is very hard to leave the occupied territory now, because there is no evacuation channels or ways. You need to travel a lot and pay a lot of money to leave the occupied territories. Yet some people manage to come back to the occupied territory of Ukraine. So we do interview them. And unfortunately, some of them are also survivors of war crimes at minimum. Yeah, so thank you.
Thank you very much. But Caroline or Philipp, do you want to take? Philipp, you're putting your hand up. Great, thank you. You could address the other part of the question from the court. How does the court deal with these kinds of crimes?
Hi, yeah. I think there's a theoretical answer, and then there's a practical answer. The theoretical answer is again twofold. Number one, OTP, Office of the Prosecutor. I think that you will find that the Office of the Prosecutor, in their strategy and techniques to investigate gender crimes, has really gone into a new era of professional interviewing techniques. It comes with a new policy. And I think that really the OTP is, from what I hear on how they are doing things in the field, they're really extremely professional in terms of having psychologists taking the time and the space, safe space, being able to also have a corresponding person that would be the least intrusive to the potential victim / witness to speak. There's an entire witness protection program that is generally available, but in particular for gender crime victims, there's really there's specific knowledge and expertise that has been added in the last years that really sort of provides for a top-notch approach. That is the OTP. Now here comes the registry. So for victims that come to the registry and that want to participate as victims, again, we may be facing exactly victims with similar patterns that either have been in touch with the Office of the Prosecutor or they haven't, right? And we have way less resources than the Office of the Prosecutor in order to provide the safe space and the entire surroundings, in particular with regard to the psychological care that, you know, for the OTP comes with a psychologist in sur place. So here we are actually, say, the best we can do is we have constant periodic trainings to the field staff that are in the field, that are directly liaising with victims, that receive sort of specific interviewing technique training, trauma training, so that they are well trained to understand early in a potential conversation, here is something that is heavily traumatic, in particular when it goes into the direction of potential gender crimes. And then we know sort of what are the key aspects to tackle in order to not run into a traumatization of the victim by continuing to ask questions and thereby soliciting potentially information where we're not equipped at that particular moment to really cater for that and to find the sort of the perfect forum for doing this. So I'm saying this because I think we all need to understand that we have to do our due diligence. We have to do the maximum to protect these individuals. But in some instances, the best we can do is basically to know early enough what is happening here, and then potentially to stop and say, look, we need to provide a different space, a different area, a different surrounding in order to continue this. So that's really the one thing that we have to keep in mind. Not everybody is as well equipped as a professional prosecution / investigation service. And I think this goes for the ICC registry person from my section just as much as for anybody else, in particular for CSO organization staff that actually are interacting directly with victims. This is incredibly difficult. One has to be really switched on in order not to traumatize the person in front of oneself, but also in order not to traumatize then the interviewer as well, because obviously you may not be prepared for what you're getting. Now, one additional point to make, and this is what is reality in particular right now, with very limited capacity on the ground. Yeah, so right now, obviously the reality is that the ICC footprint on the ground is extremely limited, and therefore everything that, for instance, as Yasmina just mentioned it, it's incredibly difficult to actually reach out to persons right now and to provide, at least to a certain extent, a safe space in order to have these conversations. So this is, I think, a limiting factor that we have to consider. What is the status quo? And therefore, I think this is something where we right now would say we don't do this on the phone. We would immediately say, no, the security comes first. We need to first create a safe environment in which we can interact. And that would then be to start with the very basic things in terms of a secure connection. Yeah? One last word on interviewing I wanted to say, because this is something that really is on our minds. what is currently happening is that there's a lot of different actors that are interviewing victims in the field. Not everybody is as equipped as the next one in terms of having had proper training, in terms of knowing exactly how to deal with traumatized victims. And the problem that this may generate is that you have sort of an over-interviewing sort of an over-interviewing happening, which has on the one hand the potential effect of imagine you're a potential witness and you are interviewed for the third or fourth or fifth time. This may come back to haunt this poor person in the courtroom if then the defense has another 3 or 4 statements of that same person. And you know how it is. If I ask you what you did last Christmas, you're going to give me a different story than if I ask you in 2 years' time. And that is with all the good intentions that you may have. Same goes for the victim-specific interviewing. You don't want to re-traumatize persons by asking them 3, 4, 5 times about the same events, which they have to live again once they speak. So I think that this is why it is so important that we are also interacting in these fora in order to prevent over-interviewing from happening to the extent possible.
Thank you, Philipp. I think, Haydée, you wanted to add something, and perhaps you could respond to another question, which is a very specific question. At what stage can victims be directly involved in the proceedings? So this comes back to the different ways in which they can participate. Yeah, thank you.
Just on this question that we've been addressing now, I completely echo Philipp, what you say about making sure to, best practices about when you're interacting directly with victims and making sure there's not re-traumatization, that there's making sure to train yourself on sensitivities to victims, especially when interviewing. And I think it's, as a general rule, whenever you engage with a victim, some of the first questions that should be asked is, have you spoken to any other lawyer? Have you spoken to any other NGO? Are you being represented? Have you given a statement before? And if they have, then you have to really carefully think about the strategy and whether that's best for the victim's well-being and also for their legal interests at the court as well. So definitely agree with that. And I think that's just some best practices that are really key to follow. But I just wanted to jump in on the point about the prosecution having, more resources to provide protection for victims who are, extremely vulnerable, which is the case, and I understand that every organ of the court is stretched, and the prosecution might have more of this, but as a lawyer or an organization that's representing victims, we also have to understand the reality that when you go to the prosecution and approach the prosecution and alert them to the fact that you're representing victims and they have this type of evidence, that doesn't mean that the prosecution will necessarily engage with them, or that they're going to take their evidence and that those victims will definitely become witnesses in a case. That's a very small number of victims. So it's up to your legal representative or the organization you're working with when they engage the court. It's still meaningful in the sense that you're providing evidence about the victim's situation, but that extra step where that victim becomes a witness to the court is few and far between, and therefore the prosecution is really only going to provide that protection to those witnesses that it's using to support its case. So we can't look to the prosecution as being a source for all victims to potentially get any kind of protection or support they need in making sure that their well-being is protected before the court as well, just as a matter of making sure that that's clear. So oftentimes it's going to fall back on us as legal representatives for victims or for organizations that are working with victims in those early stages before a case kicks off at the court. Oftentimes that can be years that we're working with victims, and we need to establish a relationship with victims and make sure that we're checking in and that they're doing well. And it's an extraordinary amount of work to make sure that we're taking care of those personal and well-being aspects in addition to the legal aspects as well. And I think that just kind of goes back to the point that I was making about, I'd love to see more guidelines and, a really thorough discussion with the court about how the court might have the capacity to support legal representatives and organizations working with victims in the early stages. But just on that question about at what stage can victims participate, almost from the very start, as soon as there's a situation that's open to the court, then that's when victims can start participating in the court. So it's really from the start. There doesn't need to be a case, there doesn't need to be an indictment or an arrest warrant. It's that early stage when the court opens a situation, that's when victim participation can start. Now, there's also the Article 15 submissions before a situation is opened. If there's a crime that's committed within the jurisdiction of the court, then potentially a lawyer could, submit evidence to the prosecution. But I think the procedural status or standing of victims to participate is much lower. There isn't a standing to participate. It's more so just a mechanism for supplying evidence to the court at that point. So stop there.
Thank you. Okay, Philipp, briefly, because I can see you putting your hand up, but I wanted to move on to another question, but do go ahead.
Sorry, just very briefly, for the direct interaction, that would happen at the case stage after the prosecution case. So after the prosecution has submitted its evidence, it will end the presentation of its own evidence, and then the chamber will usually provide a phase for the legal representative of victims to address the court immediately and directly. This is the stage where the victim representative may choose to actually have victims directly speak in the courtroom to the judges and to the parties and to the public. Usually this will be victims that would be representative in their harm of what has been experienced by the larger constituency. So that is just to specify on this point. This is the moment where victims speak directly in court. It's a very, very small number of victims to be chosen by the legal representative, but that is where this is possible.
Thank you very much for that clarification. I wanted to move on to a question which is often misunderstood, so I think it's really important to clarify, and that's about the principle of complementarity and what does it really mean, because people are used to other international courts, where human rights courts, where a victim first has to go before a national court before being able to bring a case at the international level. And so the question is, how does the principle of complementarity fit with what's been said about the victim being able to approach the court at any time? So the questioner says, what is the point of this if you have to start with the national authorities anyway? And of course, the complementarity before the court is different to the, it's not about whether individual victims have taken their complaint first to a national court. Who wants to take that one? Caroline, you're smiling?
I think I can start giving some general lines on complementarity, and maybe Philipp will want to add on specifically. The complementarity at the court is understood as the court is sort of the emergency wheel of the car. So when national proceedings are not taking place or are not genuinely taking place, then the ICC can have jurisdictions. That means that the primary responsibility to prosecute crimes, the crimes under the jurisdiction of the court, belong to the national authorities, to the national tribunals. And it's only when this doesn't happen that the ICC gets jurisdiction. It doesn't mean that one is the first step for another. That's very clear. And in particular, in the case of Ukraine, the prosecutor already made some statement explaining a bit what he has in mind for the complementarity. Usually, the ICC will deal with those bearing the biggest responsibility in the commission of the crimes, while the national jurisdiction would then deal with the biggest amount of perpetrators, if you want, right? So the ICC will be dealing with a little key numbers of cases that are maybe harder to deal with at the national level for political issues, for protection of witnesses issues, and for many different issues, while the national jurisdiction would kick in to deal with the majority of the case. That's what the prosecutor has in mind when he's talking about his pyramid of complementarity. I guess Philipp can add on these steps of victims going first at the national level and not.
Go ahead.
Maybe very briefly, in the interest of time, I see Fiona's eyes on me. So no, very briefly, I think this is, for instance, also why I think it's so important to be serious about victim participation at the situation versus the case stage, and why we're taking a rather reactive approach at the situation stage. At the situation stage, specifically in a situation like Ukraine, obviously everybody's looking at, you know, how is the national legal system picking up, and how well this will develop over time. And this goes across all situations. So because it would be obviously problematic if victims were to first come forward to the ICC, and then we actually see a massive shift over to the national jurisdictions, which we would want to see as per Article 70, as per the entire idea of complementarity. And then we would have a different yet very interesting question. How can the ICC, or how can we, the registry, potentially create a space for victims to actually then go to the relevant national jurisdiction? So this is, I think, very important to think about, how we link relevant actors early in time. However, again, in order not to have, say, a problem that would go into the thousands of individuals that would sort of have to shift jurisdictions, we're putting limelight of our activities in terms of actively reaching out to victims at times where we know, or we know with sufficient certainty, that Article 70 may actually not be an issue, because proceedings will start at the ICC, and it is very unlikely that they will then still shift back into the national. But I think, again, this is a very, very important point that we would all have to work on hard, in particular in a situation like Ukraine, in order to prevent any problems from happening through proper connection of national and international offices of this kind.
Thank you. And just to be clear, a victim does not have to have made a complaint before a national authority in order to apply to be a victim before the ICC. I think that's just worthwhile clarifying. We have a question about materials that, or further materials that might be prepared. So the question is, what other materials would be useful for survivors, in your opinion, and what support could be useful to Ukrainian CSOs on outreach, especially to communities abroad? After all, there are many Ukrainian victims who may be outside Ukraine at this point. And so actually a question to Haydée, do you think it would be useful to create similar guides in other situations? And question to Philipp and Caroline, what are you planning in terms of creating such tools in other situations? But I think I'm going to start with Yelyzaveta on the first part of the question, which is, what kind of support would be useful to Ukrainian CSOs on outreach to communities, Ukrainians abroad, Ukrainian victims who may be abroad?
Well, actually, that's kind of a question, because we mostly work with communities in Ukraine. So we do work with communities abroad, but only regarding the well, I forgot the word. Боже, дітей перевозять коли. So this word is so obvious, and ICC is investigating this forcible transfer of children. So there is a word on I am so sorry, all my colleagues forgot this word. So we had this when we were studying on this question, we had some trips to different countries and to different communities, like who helps Ukrainians to socialize in this or that country. So that was, if I get the question correctly. So this was one of our experience of engaging with those Ukrainians who left Ukraine. Yeah, hope I answered the question. But unfortunately, due to the specific of our organization, we mostly work with those Ukrainians who were or still is living in the occupied territories of Ukraine.
Thank you. Benji, I wonder if there's anything you want to add about maybe Redress's thoughts on reaching out to victims who may be outside Ukraine, and also on the question about whether you're planning to issue further materials, either directed at Ukraine or other situations.
Yeah, as regards reaching out to other victims abroad, I think we have also been preparing social media campaigns to make sure that this guide reaches a broad audience. Particularly, also we made it available in other languages as well to make that usable. And so to the extent of reaching other victims abroad, we hope that social media would be able to do that, and also the CSOs might be able to help. As regards to the derivative materials or adopting the guide to other situations, the guide that we released is indeed, it can be used, although it's a Ukrainian focused guide, the structure of it and also most of the contents could still also apply to other situations. And if there are organizations who might want to apply the same guide, use the guide as a model to make their own guides specific to their situations, and then Redress will be happy for a guide to be used as a model for that.
Thank you very much. Any thoughts on further materials? Caroline, yes, go ahead.
Just a little something on our side about reaching out to Ukrainians abroad, so those who left. In our trainings with the media representatives, we've made sure that we included a lot of those who are very active online, on social media, that are also opinion leaders that are followed throughout the world by Ukrainians abroad. So that there will be also some information properly passed to those communities. So this is one angle that we've already started to work on, and the diaspora or the refugees or the people in exile is always in our mind, might not be our first priority right now, but in the future, we're hoping to develop strategies in order to reach them. So if any CSOs, NGOs have access to groups, it's always difficult when people are scattered, right? But if you have groups, then for us, it's always easier if there are events more targeting these people, these communities, then we're happy to also take part of it. And that's a general note. Whatever we can do, such as participating in online events, providing tools, providing speakers for conferences, these are things that we can easily do even within our small resources. So please reach out to us if you have in mind outreach activities to talk about the ICC on Ukraine, but in other situations as well. Don't hesitate to come to us. We'd be happy to try to accommodate them. That's the list in a way that we can do. As to having other tools equivalent to this guide for other situations, yes, absolutely. This is always useful, of course, bearing in mind the fact that it has to be tailored to the different phases and stages of the proceedings. But, I can imagine very well a guide, equivalent guide for the Philippines currently, for example, or for Bangladesh, Myanmar, and I mean, and that's just examples that I have in mind, but yes, absolutely, we could think about it and see if there are interest from the CSOs to work with us on these things. We would be delighted to help. Yes.
Thank you very much. We're almost out of time, but I am going to sneak in one question because I know it will be on a lot of people's minds. And that is about safety and security. Perhaps address this one to Philipp. What kinds of safeguards does VPRS provide for victims in light of their safety and security is the question.
Well,
Easy one to end with.
Thanks. An easy question for the end. I think this has been our common headache, Fiona, both on when you were heading the section and now for me. The real protection that we can provide is very limited in terms of active protection. What we can do is we can try to provide our partners with the do's and don'ts of how to communicate. So that is the initial communication where, for instance, you can immediately move the communication to platforms that are more secure. That is, without wanting to mention them now, the more secure privately available platforms of communication. Yeah, that's number one, which, for instance, was sort of a key issue for us in situations like Philippines, Venezuela, Afghanistan. The list is long, right? The other is then the communication of the do's and don'ts. If you interact with someone from the ICC, don't tell anybody. If sort of the essentials of how do you want to interact with us? Don't leave a trace, say, on your computer. Don't print out materials. All these things that may be completely intuitive to us, but which may be something that the victim may not have thought about. Basically, we're trying to alert our interlocutors of the security risks because we cannot provide any active protection. Active protection is reserved for those that are in direct interaction with, say, for instance, the Office of the Prosecutor in terms of potential evidence. So if you think of potential witnesses, there are the witness protection programs as we know them, or also individuals that may be in touch with the Office of the Prosecutor or the court for matters such as this one. But when it comes to your interaction as a victim, in particular at the early stages, say situation stage, with the registry, with the VPRS, the protection that we will be able to provide is advice on secure levels of communication, and finally, the secure storage of any information that we receive from victims, which means that we have a heavily secure database. We do not share the information that we receive from victims with anybody at the situation stage. And when a case starts, only with the chamber and only in very limited circumstances with the parties. Think, for instance, of a victim witness, so somebody who is also testifying in court, where certain information has to be shared with the parties, but not publicly. Yeah.
Thank you, Philipp. I'm sorry to cut you off, but I'm afraid we're out of time. This is not the end of the conversation, though, and I understand that people who have put questions, I apologize, we didn't quite manage to get to all of them. There's some important questions that were put, but we are going to try to respond to those by email. Thank you enormously to the panelists for taking the time and providing such wide-ranging and really helpful input. And thank you so much to everyone who's attended. And I think very last word is that I believe Eva is going to post a poll on screen. Thank you so much.